Good evening. I'm so happy to welcome you all here to our first Sober Second Thinkers Talk of the 2025-26 academic year. My name is Linda Harling-Stalker, the director of the Brian Mulroney Institute of Government here at St. FX. This evening, we meet in Mi'kma'ki, the ancestral and unceded territory of the Mi'kmaq people. They have stewarded these lands since time immemorial, for which I'm truly grateful. This month is Mi'kmaq History Month, and we are called upon to fulfill our treaty obligations and work toward meeting the recommendations set out in the Truth and Reconciliation Report. Its chair, the late Honourable Murray Sinclair, stated, "Education got us into this mess, and education will get us out of it." As an educational institution, it is incumbent upon us to not only educate our students, but also ourselves on the triumphs and struggles the Indigenous communities have faced. Tonight's event will certainly provide us with one opportunity to do just that. I am so privileged to introduce and welcome this evening's speaker, Canadian Senator, the Honourable Kim Pate. The Honourable Kim Pate was appointed to the Senate of Canada on November 10th, 2016. So her anniversary is coming up very soon. First and foremost, the mother of Michael and Madison. She's also a nationally renowned advocate who has spent the last I'm going to give you just 25 years, last more than 45 years, working in around the legal and penal systems of Canada with and on behalf of some of the most marginalized, victimized, criminalized, and institutionalized, particularly imprisoned youth, men, and women. Senator Pate graduated from Dalhousie Law School in 1984 with honors in the clinical law program. She was the executive director of the Canadian Association of Elizabeth Fry Societies from January 1992 until her appointment to the Senate in November 2016. She has developed and taught prison law, human rights and social justice, and defending battered women on trial courses at the faculties of law at the University of Ottawa, Dalhousie, and the University of Saskatchewan. She has also occupied the Sallows Chair in Human Rights at the University of Saskatchewan College of Law in 2014 and 2015. Senator Pate is widely credited as the driving force behind the inquiry into certain events at the Prison for Women in Kingston, headed by Justice Louise Arbour. During the inquiry, she supported women as they aired their experiences and was a critical resource and witness to the inquiry itself. Senator Pate is also a member of the Order of Canada, a recipient of the Governor General's Award in commemoration of the Persons Case, the Canadian Bar Association's Bertha Wilson Touchstone Award, and 6 honorary doctorates. Quite an accomplished woman. As part of our mandate here at the Brian Mulroney Institute of Government, we are to initiate conversations around key policy concerns. And this is why we launched the Sober Second Thinker Speaker Series. In this series, the Mulroney Institute invites sitting and retired senators to give their reflections on their time in the Senate and to talk about the importance of sober second thought in an era of increased partisanship and divisions. Over the course of a day or two at the university, the senators will present the public lecture that you hear tonight and engage with students. And so we aim to involve our students here at St. FX, as well as the community at large, where we can hear about senators' knowledge and insights as participant observers in one of the nation's central government institutions. This evening, Senator Pate will present Reconciliation Requires Us to Decolonize, Decriminalize, and Decarcerate. She will focus her comments on the importance of building community resources and supports via the experiences and miscarriages of justice visited on 12 Indigenous women in the residential school, child welfare, education, and criminal law systems. Their life trajectories reveal the need for significant systematic changes and underscore how and why we must decolonize, decriminalize, and decarcerate. So please join me in welcoming Senator Pate to the podium.
Thank you very much. It's been an incredible couple of days. I was just saying earlier, it feels like more than just 2 days. I just arrived here yesterday morning and it feels like a lot longer than that. It's been such a rich opportunity. I want to thank you for acknowledging the territory. I usually hail these days from the shores of the Kitchissippi in the unceded, unsurrendered, and unreturned territory of the Anishinaabe Algonquin Nation, otherwise known to many on Turtle Island as Ottawa. And it's important for all kinds of reasons. We know that this country that we call Canada, we're grateful to the stewards of the land, the First Nations who took care of the land for millennia, and as well as those who came whose labor often wasn't recognized or appropriately compensated, who have built this land. And I think it's really important that we have these opportunities. So when I talk about reconciliation requiring us to decolonize, decriminalize, and decarcerate, I'm going to focus today on some particular examples through the lens of 12 women I know very well, but you can extrapolate beyond that, and I hope we'll have time for rich conversation afterwards, because it always is wonderful to be in dialogue as opposed to giving a monologue. So I think that's more fun for you too. I want to really thank Dr. Harling Stocker. I just realized I've been referring to you only as Linda, and I had to look at your, I'd written down your name, thank goodness, as well as Elder Prosper, as well as so many people, the professors and the Board of Governors, Anna, who's made sure I got to where I should go. And I swear she talked to all the people I've known for many years who say she's always, you have to find her and she won't be on time if you don't nag her. But she didn't nag me. She just got me from place to place. And I want to thank you all for being here, because for me, the energy and the enthusiasm of these sorts of issues comes from the work that we all do together. And I want to recognize, I don't usually do this, but when I hear that introduction read out, it's a standard introduction we have. When I first joined the Senate, the team in my office said, you have to do an introduction. I say, oh, Kim Pate. And they didn't find that very helpful. But they did some research, and Archie Kaiser had once introduced me. So that introduction is actually thanks to, it's a bit of the world through Archie's eyes with my staff adding in. So thank you very much. But I want to underscore that when we're talking about sober second thinkers, and I love the name of that because, of course, the Senate's supposed to be the chamber of sober second thought. It's also supposed to be the chamber that looks after the issues and interests of people in this country whose interests and issues aren't necessarily represented by elected officials for all kinds of reasons, either because they're seen as quote unquote minority interests, they're not seen as vote getters. And so it's really important that you're doing this. And so I want to thank St. FX for initiating this. I suspect, especially seeing as you just got #1 in reputation in Maclean's, other universities may start to emulate you. So, maybe our senators should be stepping up our game as well. But I think that oftentimes people like me get to be in these positions and it looks as though it's one person acting alone, but none of us ever achieves anything alone. Everything I'm going to talk about, including the relationships I have with the women I'm going to talk about, is the work of collections of people, collectivities, and it's across often interests, challenging each other through those interests. And that's really how we build momentum in this country. It's not by one or two people taking leadership positions. And thank you for mentioning Murray Sinclair, because Murray used to always say, if you're leading from within, then you're actually leading. If you're at the front of the line, you just got in front of the parade. And that's a bit, I think, how sometimes I think of what our role is to try and be within. The other reason that I picked this title is because It is more than 10 years now since the Truth and Reconciliation Commission calls to action were issued and the final report was tabled. And one of the recommendations, there are many calls to action, but number 30, those of you who study this will probably know which one I'm talking about right away. Number 30 is to end the overrepresentation of Indigenous peoples in prisons. In the nearly 50 years now that I've been going, yes, I'm really old, going in and out of prisons, it's been painfully obvious to me that who is imprisoned is more a function of what you have, or more importantly, what you don't have, and how many systems have failed you. Prisons are full of the people who are failed by every other system. And as Dr. Linda, I'm going to call you Dr. Linda, sorry, because I just now changed my notes and can't find your full hyphenated name again. And I mean no disrespect. I'm sorry. That sounds incredibly disrespectful, but I don't. And everybody, please call me Kim. But you know, when we look at these systems and we recognize that they are supposed to be about alleviating inequities or substantive inequality, but you see that they perpetuate them, we know we have to do something different. And when you see right in this moment the call for more law, so-called law and order, which actually produces more laws but less order, and in fact disproportionately will impact those who already are at the intersections of marginalization and discrimination, then you know we have to do something different. When you know that the Missing and Murdered Indigenous Women and Girls Inquiry, which is also more than 6 years since they tabled their calls for justice, talked about the importance, both the TRC and the MMIWG talked about the importance of building up community and tearing down some of the existing power structures. And they talked about it that way, and they talked about the role in particular of Indigenous, MMIWG in particular, about the very same issues that give rise to Indigenous women being more likely to be disappeared, murdered, homeless on the streets, are the exact same issues that result in them being disproportionately criminalized. And what are those numbers? Many of you know them. Students could probably rhyme them off. What's the proportion of Indigenous women in federal prisons? Anybody know? 50%. 1 in 2. Tomorrow I'm going to Nova when I leave here. 1 in 2 women in federal custody serving 2 years or more are Indigenous. 1 in 3 men in federal custody. When you go into provincial jails, particularly in Saskatchewan, Manitoba, and the 3 Northern Territories, and in those provincial jails, it's anywhere from 80 to 100%, depending on the day. When you go into youth centers, it's even worse. 95 to 100% of those in prisons designated for youth, young women and girls, are Indigenous. So the situation is not getting better, it's getting worse. And now I have a chart that I want to use to help try and illustrate that. This chart, if anybody's interested, you've got the QR codes. I'm a techno-twit, by the way, so you know it's the incredible young, and I stress young because their brains are way more agile and creative and leading in this way. They have created these QR codes. It's in this particular report, which is the report I'm referring to tonight, on page, I believe it's page 4, if I remember correctly. Yes, it is page 4, in with some other material. So anybody who wants to get access to it can get it. Any of this material that you see, feel free to use. You don't have to come and ask if you can use it. Download it, stick it on your own letterhead. Maybe don't plagiarize for if you're doing it for a paper, but that's just the old professor in me talking. But use the material because that's what it's there for. This chart shows the rates of incarceration since the Supreme Court of Canada and the Royal Commission on Aboriginal Peoples said we had a crisis of overrepresentation. So you see 1991, the RCAP report, and the Aboriginal Justice Inquiry, which was Murray Sinclair. That's how I first met Murray, or the former Senator Sinclair Iban. And then you see it going through. And what do you see happening? As we spend more and more time trying to reform the system, what's happening? We're making it easier for the system to feel okay about putting more Indigenous people. Now, nobody would articulate it that. No judge would say that. No legislator, well, except for me, maybe, but would say that this is the aim of this legislation. But when you look at the results, why is it that way? Well, what are we talking about? CCRA. Those of you who aren't involved in corrections may not know what that means. It refers to the Corrections and Conditional Release Act. When it was introduced in 1992, it was supposed to be a piece of human rights legislation with a primary focus on redirecting so that people would be in community first and foremost, not in prisons. So we see what happens there. We see in it, it also allows for Section 81 and 84 allows for alternative ways for people to be incarcerated in community. So for particularly for Indigenous people, it says that they can serve their sentence in a community or they can be paroled into the community. Sentence is 81, 84 is paroled. Now, I often use the example, they put that in the law, but then didn't tell anyone. Now, how many, I'm trained as a lawyer, you've heard. I don't read every single piece of legislation the minute it comes down. How many First Nations do you think knew that was in the law and that they could be applying to have their people stay in their communities and get resources to do it, funding to do it? It costs on average, correction says about $200,000 per year to keep a person in prison. If you're talking about Indigenous people, Black people, people with mental health issues, you're talking closer to $400,000 per year and upwards of $500,000 per year. Why? Because they're more likely to, because the whole system is discriminatory, they're more likely to be kept in higher security, have less access to programs, and that all costs more money for correctional officers and guards, not necessarily programs. And so they often also stay longer in prison. And so we see this push for the first healing lodges. The first healing lodge, that envisionment was Indigenous women who were as part of a circle of the Task Force on Federally Sentenced Women, which was the task force. The first time ever, there was a task force made up of half government people and half community people. And included in those community people were people who had been in prison. It was the first ever that there'd been something on imprisonment that looked like that. In Nova Scotia, actually, there was a very similar task force happened, and they produced a very similar report to the federal one. It's called Blueprint for Change, yet many people have not even heard of it because it never got implemented. At the federal level, they were supposed to start building small community-based prisons. So Nova, anybody who ever went to Nova when it first opened, there was not a big fence around it. There wasn't a big maximum security unit in the middle of it. The gymnasium is on the sidewalk or on the parking lot. Why? Because the expectation was community would go in and use that, and that women would go out into the community for programming. So the programming space was probably not much larger than maybe double this room, because the expectation was women would be going out. When I first visited the site where Nova was being built, there were 13 women serving federal sentences in all 4 of the Atlantic provinces. But they built the prison initially to house almost 35 women. Now it can house over 100. So it tells you that moving a prison closer made it more convenient for people to sentence, for judges and for lawyers, quite frankly, to argue for incarceration. There's often a myth that you get more programs if you get a longer sentence. Anybody who's been in prison or knows people who've been in prison know why I'm calling it a myth, because generally you don't get access to those programs until you're close to the end of your sentence, or you get limited access. And I often say to people, if you're getting a whole list of programs that are operated, whether it's Nova, Spring Hill, Dorchester, Renouse, ask people, how long do the programs last? How long in a day? How many hours in a day? How many people get access? And what do they get at the end? And what's the results? Very different picture than just getting a whole list of programs. So we have the first healing lodge is opened. It's designed, the initial one was supposed to be run by an Indigenous community. Okima-Ochi is the name of the lodge, and it was supposed to be run by the Nikanit people, which is a group, a First Nation down near the border of Saskatchewan, Alberta, and the US, so in the Cypress Hills. And within a couple of years, the Nikanit people had been convinced that they'd never be able to run that. They didn't have the capacity. It was incorrect, but they were told that it would have to be run by corrections. As well, before that lodge even opened, there were other lodges being opened in men's prisons. And what they are is basically minimum security prisons. Now, the Healing Lodge was supposed to be designed for the women who were at prison for women, most of whom were classified as maximum security. In fact, when I first started at my job at EFRI, I was approached by Sharon McIver, who was then the speaker, now would be the president of Native Women's Association of Canada. And I was asked to not blog, not speak out against a secure lodge, a safe lodge, they called it, going into the Okima-Ochi Healing Lodge. Why? Because it was the only way they could get corrections to agree that women who were classified as maximum security could go there. To this day, more than 30 years later, there has never been a woman classified as maximum security there. That's a policy decision. That's not a legal requirement. Instead, they only take really minimum security. They've taken a few women classified as medium security. And lest you think they can't change those policies, when they were trying to close the prison for women, they closed it down in 2000. In 1995, when the Arbor Commission was happening, and then when the report was tabled in 1996, there was a huge push to speed up the closure of the prison for women because there was so much bad press coming from the Arbor report. And so they started to move, but there was huge pressure also to not transfer higher security women to the regional, I call them new, this shows my age, they're over 30 years old, all of them, but to the new prisons. And so instead, what happened is women were transferred into prisons for men. So here in the Atlantic, women were transferred to Spring Hill. A lot of people don't know that for 8.5 years in the early 2000s, late 90s, early 2000s, women right across the country who were classified as medium and maximum security, every Indigenous woman and Black woman except one who was 18, who had just been transferred up from the youth system, were transferred into those units, segregated units in men's prisons, except in Ontario. Why? Because in Ontario, the women who were left at the prison for women who were going to be transferred eventually to Grand Valley, they wanted to move them to Kingston Penitentiary. We'd already had an order in 1994 to force the women to be moved back after they were illegally moved to KP, after the incidents that gave rise to the Arbor Commission. There was a court order forcing them to go back. So the women weren't afraid to fight that fight again. And as I say that, I'm not putting responsibility on the women in the other units, but in all the other units, as they were moving women to the men's prisons, they held them in remand centers across the country, and they were treated abysmally. And so the threat to those women, every group of women wanted to launch a legal action, but they were all threatened with, if you launch that action while the court case is taking place, you'll all be shipped back to the remand centers. So it was a huge disincentive. They by then had been in the prisons designated for men for a period of time, and while they weren't happy, they found that preferable to being shipped back to remand centers. So in that period, what's the point of that, you say? Well, corrections would say to you, the classification system is not racist. I say to you, it's absolutely racist. The Human Rights Commission in 2004 said it was racist, ableist, because it disproportionately impacted those with mental health issues, and that it was sexist because disproportionately women would be classified as higher security, often for behavior that a man might stay at minimum, they might get classified as medium or maximum. Talking back, swearing, yelling, that kind of thing. So what was different for the women at P4W is they said, we're staying. Corrections wanted to close the prison for women, and the women dug their heels in, and we lawyered up, as they say, and they were ready for the fight. So what did corrections do? They reclassified all of those women as lower security. For almost 2 years in this country, there were no women in the Ontario region classified as higher than medium security. Now, does that mean suddenly there was nobody that could have been? No. It was a policy decision because they wanted to close the prison for women and they wanted to move those women out. And if they moved anyone with maximum security, guess what? It raised a new court case for all of us in all the rest of the country. And they didn't want that because they knew we'd do a representative action. So all of that to say that that's some of the backdrop to now where we are, whereas the TRC said residential school or prisons have become essentially the new residential schools. That the type of representation, you all know that now those who are in Indigenous people and child welfare outstrips the highest number of Indigenous young people in residential schools or day schools at their height. So the situation is not improving. So I'll come back to the chart. So the Healing Lodge opens, it gets subverted. Then we have, the government in 1992 passed the corrections legislation. In 1995, they say we should actually really focus on how do we minimize the use of incarceration. So they introduce section 718(2)E of the Criminal Code, otherwise known to many of you as Gladue factors. I'll tell you in a minute why I don't call them that. And they introduce it and they say with the express purpose of there's already a provision in the sentencing provisions that says you're supposed to use imprisonment with restraint. Subsection E merely says especially Indigenous people. So it's not a new system. It's a reminder to judges, to courts, to lawyers, especially, and you have an extra obligation. And then the first case that goes to the Supreme Court of Canada to interpret it is Jamie's case. Now, Jamie's described, any of you read her case? Anybody know how the facts are described? Don't worry, it's not a test. I know you're all in midterms. I shouldn't even do that to you. So Jamie's described as a jealous wife who stabs her husband because he's having an affair. So I meet Jamie, and more to the point, all the women who knew her said, that's not right, like how they're describing it. So you think, how did her case get to the Supreme Court of Canada? Well, it got there because her lawyer, 718(2)E was new. Her lawyer said she was pregnant when she was being sentenced, and her lawyer said we should actually, I think that new provision, 718(2)E applies. And the judge said, no, it only applies to Indians on reserve or Natives on reserve or Aboriginals. I can't remember the exact terminology, but what it basically says it doesn't apply to Jamie because she's on reserve. Nobody ever interrogates what we in our Defending Battered Women on Trial course get all the students to. When I say we, Professor Emeritus Elizabeth Sheehy and I developed the course, Defending Battered Women on Trial. That's a whole how and why we did it is related to a review we were doing post Lavallee, which is, I don't want to go off on that diatribe, but so we got the transcripts of the preliminary inquiry. Now, preliminary inquiry is basically when the court looks at the evidence and says, is there enough evidence to proceed? Or should we not proceed? It's not a high bar. If there's evidence that you did something, in this case, Jamie stabbed her common law, then chances are I'll proceed. But what also comes out during that time is that there's a history of abuse. And almost immediately, the Crown offers a deal, offers for Jamie to plead. She's charged with murder. They offer for her to plead to manslaughter. And because we don't have a mandatory minimum yet in those days, back in the 90s, for a weapons offense, they argue for a conditional sentence. It looks, most respectable judges or lawyers would not turn their nose up at that. But what it means then is we never look at why I argue Jamie was wrongfully convicted. Jamie was 19, pregnant with her second child from a very abusive man who had moved her recently from Calgary, where she lived and was supported by her single dad, who had been clean and sober for more than a decade, moved her from Calgary to Vancouver Island to Nanaimo. And he had already been jailed for beating her. I don't need to tell anyone in this room how unusual that is, that someone who had beaten an Indigenous woman was actually jailed. And the night that she stabbed him, he had, and her father then moved the rest of the siblings to live beside where Jamie and Reuben Beaver lived because he was so worried about Jamie's safety. And he had a rule, none of the other children were allowed to be left alone with Reuben Beaver. The night Jamie stabbed him, he first beat her, went next door, broke in through the bedroom window, raped her sister, came back, told Jamie about it, and when Jamie stabbed him, he was trying to get back in through the front door. I ask you if that sounds like a jealous wife, or if that sounds like, at the very least, defense of other. I would argue possibly self-defense too. But none of that gets fully interrogated ever by any of the courts because she enters a guilty plea, and then the case becomes about sentencing. So that's Gladue. Then Ipili says, yes, you're supposed to really look at sentencing. Then we get to the TRC calls to action, MMIW, C22 and C5, which we're supposed to start to get rid of mandatory minimums. Call to action number 32 is to get rid of mandatory minimum penalties. And so as each stage, what do you see happening? The correctional investigator releases its report about, and we all say, if it was a crisis back here, what do you call it now? What language do you use to call it? And so that's why we did. And, the reason I did the chart is Justice Laforme had asked me to be involved in some judicial education in the past. And I was invited to speak to a number of judges and lawyers at a conference in Vancouver that soon will be 4 years ago. And I was trying to figure out, how do I get this across to judges and lawyers? And I thought the only way I can think of is to chart it like this and just show these are all the efforts to reform, and look what our results have been. So what do I propose we do? Well, first I'll come back to the report. So what I started talking to folks about is, how do we actually build up community? Because the more we reform the system, the more we put more resources into prisons and the criminal legal system. I don't call it a justice system. It's probably pretty obvious by now why. And so the more we put resources into that system, guess what? That's where we put the people too, because we aren't feeding the community. In many communities, we don't even have clean water. In many communities, I was just up in Pikangikum. I was telling some of the students earlier, and one of the things that was shocking to me, it was great. There's been such a focus on First Nations education and language development. We went up to Pikangikum. There's a brand new, beautiful school there. There's a childcare center. They have their own generator. They have their own water system. Spitting distance, literally, from there are houses that have no running water and no proper sewage system. So we're doing these fits and starts of providing this. The day I was there, I was going because they wanted me to see what happens on court day. Well, court day, literally, everybody flies in from Toronto, Kenora, Thunder Bay, Red Lake. So the judge flies in, the people from the court, the lawyers all fly in, and the accused are flown in handcuffs from Thunder Bay, Kenora, Toronto, where they've been locked up. Meanwhile, they take me and show me a 16-bed bail house. And I'm thinking, why aren't you using the bail house? The obvious question. Why? Because virtually everybody in the community has a criminal record. So they can't pass a vulnerable sector check that you need to work in a place like that. So the house sits empty, and hundreds of thousands of dollars every month are spent to fly in this supposed justice system, this legal system, and then they fly out again. And guess what? Most people get time served because they've been hauled, you know, thousands of miles away sometimes to be incarcerated, and then they're brought back. And so we have to do things differently. So the first time Harry Laforme asked me to pull together the context of this report, as I had been talking about these things and talking about how we couldn't even get any of the women's convictions reviewed. So then the then Minister Lametti appoints Mr. Justice Harry Laforme, Madam Justice Juanita Westmoreland Traore, the first Indigenous and Black judges at appellate levels in this country, asked them to propose a new way of dealing with wrongful convictions. Great idea. Great idea. They pull together, they meet with some of the most progressive, like the body that's doing this now in New Zealand and the folks in UK and around, and they do tons of research. And one day I get a call and they say, could you pull together some Indigenous women? Because we realize in the last 20 years, 22 years it was, only 20 men's cases had been reviewed, no women's, and almost all of them were white men, one Indigenous, one Black at that time. We want you to pull together some women to try and help us understand, the ones that you know, because we'd been talking at different times. So I said, fine, I'll see what I can do. So mistrusting of the system were those women. It was during COVID, so they did not want to meet if there was any government people in the room. Now I had to point out to them, I'm now government, and they didn't quite consider that to be government, but nevertheless, so the support people that were in place to assist the justices in doing their work weren't there. The women initially all used pseudonyms and left we were on Zoom, as you know, we all did those, well, we still do those meetings, but they were all on Zoom, and only near the end did some of them start to turn their cameras on and talk to the justices. And each of them said, you know, you start out, Kim, and then they decide whether they join in. So I started out and I said, these are 12 women I know really well. They're not the only 12 women who have wrongful convictions, not by a long shot. You'd asked me to pull together Indigenous women. So these are 12 Indigenous women that I have known for 20, 30, a couple of them for more than 40 years. And I said, every single one of them at one point or another was described as the most dangerous, violent woman in one or more of the prisons they were housed. Every single one of them has a history of residential school, either themselves or their parents and their grandparents and beyond. Every single one of them was in the child welfare system. Every single one of them has a history of abuse, usually sexual and physical abuse. Every single one of them was criminalized for reacting to their life circumstances of poverty and violence that they were trying to navigate. And every single one of them had the full weight of the law come down on them. So all of them are serving long or life sentences. 2 of them had been declared dangerous offenders. Now, when you consider there are 7 women who have been declared dangerous offenders in the country, it's a fairly good that's not even an appropriate way anyway, you get the idea if it's a representation. So I said, so I want you to look at this and look at what happens and how this happened. The forced removal and assimilation from community, from culture, from family, from language, the victimization and then hyper-responsibilization of those women. And what we mean by that, and I thank the late Trish Montour and Mary Eberts and others who we worked together to come up with these ideas, and all of these, what we mean by these, they're in the back of this report if anybody wants to look at them. But it basically means that women, especially Indigenous women, are deputized from very young age to protect themselves and the others who are in their care. And if they don't, or if they do something that might cause someone else harm, the full weight of the law will come down. So they are underprotected, but often over-policed when it comes to the harm. We also know that the response of the police, prosecutors, their own counsel sometimes, the correction system is incredibly biased against them. We know that Section 718(2)E does not really allow for the adequate contextualization of the racism, of the violence, of the experiences. And I argue that, you know, and it's epitomized by what happened to Jamie, obviously, as I've already told you. But I argue that those reports should be treated in the same way as serious psychological or psychiatric reports. I know people now, including the one one of the women in this report, who I'm going to go see tomorrow at Nova, who doesn't want her report aired at all, certainly not in public, but even in the court. Because if everybody knows that, what happened, and some people have not been held to account, there will be a couple of things might happen. Her community might turn against her. Not that they've been much there for her all the way along. Not because there's not great people there, but they're so oversubscribed with so many other issues, including child welfare issues. But so and you know, when I was meeting with the Mi'kmaq Confederacy and PEI last summer, they said the same thing. Increasingly, people are saying, if this is going to be read in open court, I don't want it. I don't want to participate. And they said sometimes the first time a community, a family may hear of the abuse and who did it is when those reports are read in public. So you can imagine the breaches of privacy, how that triggers the trauma, as well as what it means in terms of if they're trying to rebuild with other members of that community who may be invested in protecting the perpetrators. The other thing that we see is a failure to be able to even look at those circumstances in all the cases where there are mandatory minimum penalties. So when people say, when the Minister of Justice, Lametti, the same one who issued the report, had to say, I say had to say because of course they're politically bound to put forth the policy of their government, has to say that mandatory minimum penalties won't disproportionately impact racialized people or women. They know that's not true. They know that's not true. And so if it were true, when they eliminated the ones in C5, we should have seen a drop in those numbers, but you see the opposite. And mandatory minimum penalties mean the judge generally, unless they're willing to take a risk, and some do, but many don't, then they're bound to sentence the person to whatever the mandatory minimum penalty is. They don't have the flexibility to say, yeah, but this person, you know, has tried to work on these issues, has these, so they are bound by it. They also don't take into account that by virtue of that mandatory minimum, especially if it's a violent offense, and for the case of Indigenous women, about half of the convictions will be classified as violent, even though most of them are reactive. I can honestly say in nearly 50 years of doing this work, I've met one woman who, Indigenous, and she was Indigenous, who committed what I would say, and she called it, a predatory act of violence. Now, she also had her own story, as do many people, men and others as well, that she'd been abused. But she was the only woman I've ever met who wasn't first victimized by the person that she attacked, or procured by someone else who then facilitated that, or that she wasn't fighting to try and get something for a kid, or, you know, fighting in the midst of for money in the midst of a robbery, that sort of thing. And so they get classified as higher security, which means they go into a prison, they get strip searched. There's whole campaigns. In fact, one of the former wardens at Nova Institution, to her everlasting credit, when she was a deputy warden, pushed very hard to get rid of routine strip searching in prisons. It was seen as completely off the wall to many of her counterparts, especially those in the prisons designated for men. But what she said was, I'm head of security. At that time, deputy wardens were heads of security in federal prisons. She said, I'm head of security, and I can't think of any other reason besides being humiliating and degrading to actually strip search someone when there's no cause, just because we're allowed to, because it's routine. And so she actually penned a paper that all the deputy wardens in the prisons designated for women signed in 2005, calling for the end of it. Have you ever heard of that? Has that ever seen the light of day? No, it got kiboshed the minute it went to Ottawa. But she recognized that what it did was re-traumatize, and how that trauma came out sometimes is in combative behavior, resistant behavior. And so it reinforced this notion that these are women who needed to be kept in higher security. Often they ended up with additional charges. Some of the women I know have started, one of them who's still labeled a dangerous offender, started on a 3-year sentence as an accessory to her partner who was dealing drugs. She got a trafficking accessory, so she was convicted of trafficking. And she then accumulated. She's now serving an indeterminate sentence. She accumulated more than 25 years of individual charges. Ashley Smith, a name some of you will know, who we're approaching the 18th anniversary of her death. She died in a segregation cell in Ontario, originally from Moncton. Coralie, her mom, insisted that if she didn't understand how Coralie was taken away from her by the professionals when she was 15 and then sent back some years later in a body bag, then how could any mother, and certainly any Canadian, understand? Ashley Smith was described, was moved 17 times in 11.5 months, was described while she was alive as having significant behavior problems and conduct disorders. And she came in on a 3-month sentence that by the time she died had accumulated to almost 11 years in increments of sometimes days and weeks, and just a few that were a number of months. And so when she died, she was serving a cumulative sentence that would have kept her there for a while and kept her in isolation. So the unending nature of these sentences and the fact that once you're in higher security, you get less access to programs means you're less likely to be released. And every time I go, tomorrow when I go to the max unit, I will almost guarantee I'll meet someone who is going to be going out sometime in the coming months or weeks, who is going directly from maximum security to the street with no support. Why? Because she's been detained till her warrant expiry date, the date the corrections has to release because your sentence is over, or she's at her statutory release date. But if she's someone is in max, chances are most of the halfway houses will have refused to take her, and so she'll be stuck in there. So think of what is the benefit to the community? How does it protect public safety to keep people in those conditions and then release them to the street with no support? So what can we do about it? Well, collectively, we need information, we need alliances, we need understanding, and we need the courage to challenge power brokers and holders to share and reallocate resources that are currently being sucked into the prison system without any question. The new bail laws that are being proposed, they will just, it's this on steroids. We know that the issue with the bail situation is that most of the people picked up are for minor. I'm not saying it's not annoying or a nuisance or harmful to the people who it impacts, but many of them are people who are in circumstances living in the street. They're easy to catch and they get put in jail because they're not likely to reappear because they're homeless. And so they get put in jail. That's not because they pose a risk to public safety. So when the judge comes along, when it comes back before them, they say, well, this would have been, you served more than the time you would have got if you got a prison sentence. So they release them. And then the public perception and what gets told to the public by irresponsible people like me, and I say politicians is what I'm meaning, now I'm one of them, is that the way to resolve this is more of the same. We'll just put more prison cells, put more people in prison, and that'll solve it. No, show me a politician, including ones that know better from this region, from all across the country, who know that what they should be putting the resources into is housing, education, treatment, supports, not into more prisons. Because if they go into prison, at best, they'll come out again maybe with some of the issues dealt with, but more likely with fewer of those issues dealt with, and with escalated problems of now longer criminal records. So what do I suggest we do? You think, okay, Kim Pate, what are you suggesting we do? Well, I think we have to work on encouraging community to feel that we have a responsibility to collectively take care of not just ourselves, not just our families, but others in the community. That I've spent my life walking with some of these folks, and I can tell you, I can't even imagine how they're still walking and living, let alone surviving the life experiences many of them have lived. We need to be insisting that those resources go into the community. And you think, okay, well, how do we do that? Well, there are provisions I've mentioned. Sections 29 is for those with mental health issues. 81, 84 of the corrections legislation that currently exists allows for communities to take responsibility for those individuals. If you want the cheat sheet on what we're looking at, Tona's Law, which we've named after a woman is one of the women in the report and what I'm going to see tomorrow. She's now in palliative care. Her dying wish, she's got terminal cancer. Her dying wish is that we stop what happened to her from happening to anyone else. After nearly over 10 years, nearly 11, in isolation in prison, when she finally got into the mental health system, she was diagnosed with isolation-induced schizophrenia. She then spent almost 12 years in the mental health system, has now been in the community. She'd been in the community a matter of months and was diagnosed with cancer. She beat it the first time into remission. And at that time, we were working on the amendments to a bill called C-83, which was the bill that was supposed to eliminate the use of segregation in federal prisons. It renamed them, and it took away many of the current or the pre-existing safeguards that existed. This bill would say there's an added responsibility on the government to look at those measures, and there's a responsibility every time they want to isolate someone, they have to go to court if it's going to be longer than 48 hours. Why 48 hours? Because the courts have already ruled that within 48 hours you can see irreparable damage from putting someone in isolation. We all know now, after COVID, what separation and isolation can do to mental health. We've got all kinds of mental health crises in this country as a result of that. And these were people who had, many of whom, not all, had homes, had communities of support. Imagine if you were locked in a seg cell. We also are trying to work on, and the other thing it would do is allow a remedy that Louise Arbour recommended back in 1996. The other thing it would do is say that if a community, let's say any First Nation said, we have 1, 2, 10, pick a number, one person from our community who's in federal custody, and we want to provide the supports in our community, transfer that person, even if they only gave them half of the resources that they're currently getting. Imagine what you could do in community with $500,000 or $250,000, not just for that person, but for entire communities. Now, particularly Indigenous communities, but also Black communities, trans communities, all communities, you could be looking at this because the law doesn't specify it has to be just an organization, but that's how it's been interpreted. We also can deal with criminal records, we can deal with all those, and we have to remind that when we leave people behind, they don't go away. When we leave people behind or ignore them, at best, they disappear or we don't notice them. But at worst, they come back. And as one of my friends who's serving a life sentence says all the time, he says, hurt people, Kim. And he said, we have to stop this. We have to insist that the resources. Canada is a rich country, resource rich, human development rich. There is no excuse for us not to be housing, feeding, clothing, educating every single person in this country. We have the resources and we need to do it. And so if any of you are interested in you may know that's partly why my whole purpose in going to the Senate was not to do prison stuff. It was to really breathe life into our charter, to have a robust healthcare system, social system, as well as education systems. I want to see and income supports. I want to see a life more similar to what we see in some of the Scandinavian countries for people in this country. I want to see redistribution of wealth. I want to see people who are currently sending their money offshore and not paying taxes, paying their taxes. I don't care. I'm happy to pay taxes when I see it's going into benefiting people. We saw during the pandemic, as people have rushed to fringe groups, as they're often referred to, as they've rushed sometimes to groups that are anti-government, for good reason. They lost faith in the government. The government wasn't taking care of them. It's not that they want to be associated with really horrendous right-wing rhetoric, but when you're not being taken care of, and I've said to a few people earlier today, my office was right above where most of the 18-wheelers were during the convoy in Ottawa. The day that I came in, the police were waving the trucks up onto the hill. They stopped me. And I eventually had to use my senator persona. I usually don't. I said, my office is up there. Can I not go up there? And they said, no, it's going to be blocked soon. I said, how can that be? When I would go to a protest with my bicycle, I'd be told I couldn't take my bicycle. You're waving 18-wheelers up on the hill. And they said, oh, well, they're just here for a protest. I said, well, how long are they going to be here? If I'm just going up for the day to my office, why can't I park in my parking spot? And they said, well, what do you do? And so I said, well, I'm a senator. Oh, guess we have to let you through then. And I was like, but what are you expecting to happen? They clearly knew people were coming and planning to stay for a while. And then what happened over the following days really was what I had to stop and think about. I started seeing people I knew, people who were homeless in Ottawa, people who had been in prison, single moms. And I said, what are you guys doing down here? Well, it was free food, and it was good food. And there was childcare. There was places for the kids to play. There was a party atmosphere. There was socializing. People were feeling a sense of belonging, not to what we want, but imagine that you're craving human contact so much that you actually gravitate to something, even that's not in your best interest long term. But when Dr. Zhao at UBC has done some great research showing that when you don't know where your next meal, is gonna come from, where you're gonna sleep, your ability to plan beyond the immediacy is incredibly limited. So when we say to those folks, pull yourself up, it's all up to you, we are doing not just them a disservice, but ourselves by pretending that in fact people start from an equal place. So I know my time I've just gone over time, which I said I wasn't going to do. If you want to have any information about some of the other things we're working on, guaranteed livable income, free post-secondary education in universities, that usually gets people happy. Truly a robust Medicare system that includes pharmacare, dental care, vision care is within reach in this country. And I think we need to be starting to demand that at every election, of every politician. And if they're saying we can't afford it, ask them why we continue to spend on this and what are the results. By this year, by September 30th, we were supposed to have ended this. That was the government made that commitment, and yet it's worse. So I thank you all for the incredible work you do. I thank all of you who have been around today, and I've had the opportunity to meet. Those I haven't had the opportunity to meet, I hope I get to. And please keep us informed of what you're doing, because it is the work of all of us that will change this. The work of one is only the work of one. The work of all of us will actually get this happening. So thank you very much. Thank you for inviting me.
Thank you ever so much. So we have time for questions. I've got the mic so I can walk around and bring it around if anybody has a question. Like, oh, we've got one at the back.
Kim, I couldn't see you leaving tonight without expanding a little bit on the topic of basic income. And when you talk about the people coming out of prison and not having any follow-up, how do you think basic income would help there?
Well, I would think in a number of ways. I think it would help prevent more people from being in the situations where they're, for whether it's for desperation or life circumstance, they're living in poverty and they can't make ends meet, and so they do things. The number one reason women are charged usually is for fraud. Most of them don't. In the federal system, more than half are considered for violent offenses, but that's usually after a series of trying to negotiate poverty. And so I actually started talking about every policy decision for the last 15 years that I was with Elizabeth Fry Society. Every one of our policy decisions included a guaranteed livable income and national standards around particularly mental health care, but national standards around social and educational and health support. So I see it as integral to us trying to make sure there's more equality. And, you know, the obvious thing that some people will say is, well, how will we pay for it? I've talked about this, but we also should be looking at, some of you heard me talk earlier about what we've done about tax evasion in this country. You know, Percy Down, who's a senator in Prince Edward Island, that's his thing, plus getting the tolls reduced on the bridge. But his thing is, he said, at one point early on when I was, you know, I'd first met him when I went to the Senate, he said, you know, if we crack this nut, it'll fund all those things you want, you know. And I mean, he wasn't being dismissive, but he's, you know, that was my shtick from his perspective. And so I thought about it, and then I started looking at the numbers, and he was right. The Panama Papers name people who owe billions of dollars of taxes, and we have not gone after one of them, not one. And I've asked those questions in Finance Committee. We could fund the initial startup, and then we would see, I can guarantee we would see reductions. The Scandinavian countries have the lowest victimization and crime rates for a reason. They also have the lowest homelessness rates. They also have the highest educational attainment rates and the well-being and happiness. Why wouldn't we want everybody to be happy? So I see it as integral to, it's not a standalone, but right now there are over, Dr. Zhao at UBC, watch for her research, because she's now looking at the social assistance schemes right across the country. I don't need to tell anyone here probably, there is no province or territory in this country where you can live on social assistance without doing something for which you could be criminalized. There's now a bit of a stigma about criminalizing poor people just for being poor. You can't, obviously, but if they're getting, you know, women have been criminalized for not declaring money they got from a family member or groceries they got or whatever. And so we know that social assistance rates are inadequate. We know that there are over 200 income schemes. We know that when we've done it incrementally, the guaranteed income supplement for seniors, the Canada Child Benefit, those are forms of basic income. And when we've done it, it's lifted people out of poverty who get it. We stop at this notion that somehow there are some people deserving and others not. We don't do the same thing when we talk about wealthy people. How many of us walk around saying, you know, well, so-and-so and so-and-so inherited all that money. They don't deserve that. Well, maybe some of us say that, things like that. But anyway, but you get the idea. We don't question how people who get money from other means spend it, what they spend it on. And Dr. Zhao's research, in addition to Evelyn Forget's research about the Mincome Project and the work that was done on the Basic Income Project in Ontario, show that when people get money and they're homeless, within a month, Dr. Zhao's research shows within a month they're housed, within 3 months most of them are working, and within a year they have saved the state over $8,000 per person on income assistance. The fact that every time I talk to a group of social work students, they are shocked to know that the biggest employer they will have will be a social assistance scheme that will employ them to police people's incomes and morality and then decide whether they deserve to get social assistance. We should get rid of all that. We should We should streamline the administration and free up those resources to actually provide supports and services. So does that answer your question?
Another question.
No question.
Okay, we'll go here and then here.
Thanks, Linda. Thank you very much, Kim, for your talk. Apologies, I came in a bit late, so I hope you didn't speak about this already. But today, ironically, one of my classes, I talked about social determinants of health. And I'm a coordinator of the Applied Forensic Psychology program here at the university. And I actually see some of my students in the crowd that were part of that class. So really pleased to see you here. And their task today was to think of an actionable item related to the social determinants of health, not necessarily in the penal system or anything, but something that could be targeted to the government of actions to do. So there's talks about policy implications within the manual that the government has written. And I wonder if you could just comment on that, the role of social determinants of health within the justice system, within the penal system, or even more broadly, what's some action? What's some things my students here can
Well,
do?
what's the number one social determinant of health? Poverty, income, however, yeah. And it's so argue for a guaranteed livable income, argue for redistribution of wealth. On the tax evasion, by the way, I've told one of the classes, I think today, that when I started asking about this, Percy Down said, well, you know, Iceland got back a bunch of their money. So I said, no, I didn't know that. So I thought the way I learn is to go and meet the people who are doing this stuff. So I called up Iceland and said, I'd like to meet whoever did got the tax money back. And it took a little while to call around. I ended up talking, there was one investigative reporter and two prosecutors who were put on that. Now, when I ask our finance department and our justice department why we haven't gone after any of the folks who are named, like I'm talking about, we know their names. It's not like you have to go pretend and do an investigation. Their response was, it's too complicated. So I asked these folks in Iceland, you've got doesn't seem like you got a huge team. There's 330,000 in your country. How did you do it? And they said, well, we just called up Liechtenstein Bank and the Swiss banks and Luxembourg, and they cooperated and they gave us the information. We said, these people have apparently not paid their taxes. We want to investigate, and they've cooperated. Now, if an investigative journalist and two investigators can initiate that in Iceland, why on earth can't we do it here? So I think that's a project for all of you. Are there any journalists in the crowd? Journalism students? Are you going to be in? Yeah. So there you go. There is a great project to do, is start asking the questions. Why aren't we asking about it? Why aren't we probing it? There's people in this part of the country who are on those lists. So, yeah, I think so. And then the other is to look at how that links to, when I was in Norway and when I was meeting with some of the folks in Sweden and Finland who are doing work on this, they've combined income and housing. They don't see them as separable. They don't say, oh, we'll provide you housing. They consider someone still homeless if they're in a shelter, and their shelters are apartment buildings. Like, they're not shelters like the shelters that I walk into all across this country, where there's mats on the floors, there's maybe a divider for the men on one side, women on the other. It's not like that. These are homes, like apartments, but they don't consider them that person's apartment, so they're still homeless until they have their own place to live. And I don't mean owning, I mean a lot of people rent in European countries as well, and they're integrated. So you're living beside, if I was living there, I might be living beside a single mom who's on state assistance. And think of what that does then to the value and the quality of education that you're advocating for in your community. Think of that does in terms of the value and quality of your recreation equipment, the quality of your housing, all of those things. So it really, I think it is integrating those and demanding that we do that. And I think it is also saying, when it comes to people like me and politicians, we're not used to giving up power and resources. Now, I always say the benefit of being raised working class and then working at nonprofits is I didn't get used to much money for most of my life. And so it doesn't seem like a huge disadvantage to give up money, but it's a huge disadvantage to give up caring about people. And if we, if any politician, any of us wants policies or legislation that we wouldn't want for people we care about, why, I always say, why would we put it in place for anybody else? And so I think the tying in of the social determinants of health, tying in earlier I had on my SDG pins, the number one social development goal for the UN is poverty as well. It's at the root, and we have to address it, and we can, and there's no reason we can't. Thank you.
Hi, yeah, I'm coming to St. FX here as an international student for climate science and environment. I'm coming from Virginia, got out of the United States.
I'm sorry.
Yeah, thank you. No, thank you so much. I'm so happy to be here and be studying here. But when I was younger, when I was starting to learn about the whole political world and everything and all how Indigenous people were mistreated, especially in the United States and all, I started hearing about what Bernie Sanders was saying, kind of got interested in his advocacy for all these social justice and economic justice issues, like a lot like the ones you mentioned up there, healthcare, basic minimum livable income, all those things. And I just have a few different ideas around that that could even add to that in economic justice areas. And I was just wondering, is there an opportunity where I could speak with you for a few minutes after the questions and just a couple of quick ideas I have?
Sure.
All right.
I'm here and I'm happy to talk to anybody.
Thank you.
Yeah. And, I said, I'm sorry, but I won't go to the States for the next while. But I, when I ask questions in one of the committees about, now you may think this sounds foolish, and in some ways it is, but it was an obvious question, but nobody was asking. And I said, why did we let him in? 34 felony convictions. I know a whole bunch of academics who do incredible work, who had records from civil rights days, most of them, and Indigenous advocacy. And we cannot get them up to Canada to do lectures, to do education, not to take our money or do anything, but to just come here to contribute to education. And yet we have no problem providing a waiver right away for someone to come in. And a number of what I was surprised by was the number of my colleagues who thought that was shameful, that I should not have done that. And until we can actually get people to, to say the things that sometimes need to be said, they may be uncomfortable and they may be obvious, but sometimes if you don't name it, you can't actually change it. And so, I encourage that. And so I'm sorry I won't go to the States for the foreseeable future, even though I've got lots of family down there, but they have to come see me. Yeah. Well, especially, yeah.
Yeah, I just want to thank you so much for coming here and sharing your knowledge with all of us, because I think it's education and knowledge that really changes the situation and the dial. And in regards to that, I realized that TRC finished in 2015, right? And there were 94 recommendations. Actually, my apologies, that's not true. They were called calls to action. So far, there's only been 13 that have been started out of 94, and that's over 10 years later. So I'm wondering, where are we going as a country about these issues? I mean, we've got a whole pile of issues on our plate right now. And I acknowledge that, but I really think that we need to do a great deal more, in many ways. Anyway, and thank you again for being here. You were awesome.
No, you're awesome for being here and being part of this. Thank you. Yeah, I wish I could tell you it was going to move faster. That was under leadership that advocated the full implementation of the TRC and the MMAWG. So we haven't had that articulation yet from this government. So I'm really concerned. Yeah, I think we're, I think we have to express ourselves. And on Saturday, I'm meeting with a bunch of defense lawyers, and I'm going to be encouraging them to be trying to set new precedents, not to just accept, oh, that's what the law has been up until now. Let's challenge. And so, these universities, colleges, educational institutions are places where we should be thinking big and challenging ourselves to think big. And we may get constrained by practicalities from time to time. Okay, a lot of the time. But the reality is that this is where you can think big. And the fact that we're, in some cases, like I was just with a group of law students who were doing the Bertha Wilson moot. And Bertha Wilson, of course, was the first woman on the Supreme Court of Canada. She went to law school at Dal. And they were arguing the basic income case, the fact that the folks who are on the Ontario Basic Income Initiative have brought a lawsuit because the current Ford government ended that, agreed during the election that they'd continue it and then ended it. So they brought a lawsuit. And so the case the students were mooting was whether there was a positive obligation to provide financial support. And I was shocked at how few of the teams argued that. And mostly the reason they gave, those of you who are, are interested in the law in this area, the last time the court looked at this was over 20 years ago in a case called Gosselin. And they said that basically, it's up to the provinces to decide how much people get on social assistance. Those of you who are lawyers, I apologize for how I brief cases, but it's essentially what they said. And now, 20 some years later, with homelessness and poverty at the levels we have it now is the time we should be arguing another one of those cases, a positive obligation on the part of the state. I mean, if you go to countries where housing, housing, food, healthcare, and education are seen as human rights, you see very different. I think we should be demanding that in Canada. Not that it's a nice to have. It's vital. People can't survive with those things. So, sorry, I went on further, and then you didn't really need me to do that diatribe. So
Here and then here.
I just feel compelled. I'm Sister Marion Sheridan, and we're part of the Atlantic Basic Income Now group, bringing together with Tamarack Institute. And so I think you wasn't in your bio, but Kim has put forth now a bill, if you'd want to speak to that for a minute, about basic income in Canada. There have been others and they've been depleted and whiplashed and whatever. But also, I guess, as university students and within your system, how can you help to do advocacy toward that? And with all due respect to Mark Carney, we're in a different space. And so we need to say more clearly. So do you want to say anything about your bill?
Sure. Well, we have a bill. I'm not allowed to propose as a private senator a bill that would overtly cost the government money. So it's a piece of framework legislation that, if passed, would require the government to pull together provinces, territories, municipalities, and First Nations and other Indigenous governance bodies to look at this and come up with a plan for how we could develop a guaranteed livable income. It also calls, and this is where some of you may have seen during the pandemic, suddenly there was a part of the convoy gang came after me saying that I was, trying to put in vaccine mandates for social assistance and stuff. I actually got a call from someone who knows my dad. My dad's 91 and a veteran. And they said, we hear that Kim's trying to introduce a bill where, we don't get our benefits unless we do certain things that and these are all veterans on assistance. And my dad, who bless his cotton socks, said, that doesn't sound like Kim would say. So But all to say that one of the things I did that is in the bill is that there should be national standards around other things, that an income support system alone won't solve it, that there need to be national standards around healthcare and education. And so that's the part that people got fixated on and said a national standard sounded like a vaccine mandate, and then they accused me of being at Davos. And I was like, okay, we're going way down some rabbit holes now. But that's basically what the bill does. The other two bills are one for a record expiry, because 1 in 10 Canadians has a criminal record. I talked about Pekanjikam, but if every person who is entitled to get a record suspension decided to apply today, it would take almost 300 years for those record expiry, those record suspensions to be processed. So we're talking about an automatic process for people who have not been back into difficulties with the law, so they could say that their record has expired. So that's another one. One to allow judges to not impose mandatory minimums is another one. And then I already mentioned Tona's law. So those are the 4 private bills that we've got going.
Hi there. Thank you for your presentation. I am a documentary filmmaker working on a project about Black men and their exchanges with the justice system. And so far, I feel that the general public's understanding and knowledge and framing of the justice system is very much not linked to the realities. And so I was wondering if maybe you could talk to why there's such a stark difference between how people see the justice system and what the justice system actually is. And then the follow-up question would be if you have maybe some effective techniques to address that ignorance on a large scale.
Well, I mentioned earlier that the provision was brought in. We've done these booklets around Section 181, 84. This is not answering directly your question yet, but anybody who's interested talks about what the legislative intent and how communities can access those resources. So that's one that Black communities could also access. I'm showing you this report. I often say, I went to the Senate and started taking senators to jail. It used to be, people thought it was funny when I say not the way some people thought, because I arrived just after the spending scandal. But, so we named the report that. But one of the ways that I think we do it is people actually have to see what's happening and who's inside. To a senator, including some of them, now the Conservative senators are not allowed to come with me to jail. But to a senator, every senator who has gone into the prison has had a variety of responses, but they usually go something like this. This looks like my kid, my cousin, depending on who they've met with. And then when they go into the units where the lifers are and they see people who have dementia, who are in wheelchairs, sometimes on life support, you can't make that up. And then when they talk to staff who say, most of the information I get these days is not just from prisoners, it's from staff who are working in those institutions who are extremely concerned about the way that they've gone. Virtually every prison in this country is a series of segregated units. Virtually every prison in this country now. And that means that people are living in isolation. It means less access to programs, because if everyone in this room could not go to recreation together, let's just say we were all in prison together, but we count off and 10 of us can go for an hour and then another 10 can go for another hour. You won't all get to go in one day, because an hour, the daytime in a prison is about 5 to 6 hours max of workable time. The rest of the time you're either on your unit, or sometimes there'll be a yard attached to your unit you can go to. The biggest reason that I'm taking senators into jail is, one, senators, judges, and members of parliament have a right of access. And Louise Arbour once said that anybody who's involved in this work, whether it's police officers, prosecutors, defense counsel, probation officers, parole officers, legislators, has no business making decisions if they have no idea what the conditions of confinement are within those places. And so I'm trying to get more people to go in, because when I first started doing this work and came out of the prison for women in 1994, after the stuff that gave rise to the Arbor inquiry, the stripping and shackling of the women, the leaving them in isolation for upwards of a month, requiring them to plead guilty to serious offenses before they could be released from SEG, hardly anybody believed that that was true. Most times if you said, this is what the women said, people said to me, you've been conned. People said, that's not true. People said, and it was only because we got the videotape out that they saw who was actually telling the truth and who wasn't. And so we've changed a bit. It's now not always a given that if a police officer or a corrections officer says something, it's automatically the story versus the prisoner or the accused person, but it's still very much that. And at that time, I mean, now there are more people doing this work. When I first started going into the prisons and I called lawyers, we used to joke that they'd see me coming, my classmates from Dal, and they'd be like, run the other way, here comes Pate, and she's going to ask you to do something for free. And I was usually, because there weren't prison lawyers and there wasn't legal aid to do it. And you know, there are more people interested in this area, but we still don't have a critical mass of people who, you know, even though I think you'd be hard pressed to find a family in this country that hasn't been impacted by the criminal legal system, either as being victimized and or someone being criminalized, certainly the mental health system. And if you are in the mental health system now and you do anything that they can call the police. I just saw a directive that I nearly blew a gasket about and sent back. I won't say which organization, but I sent back and said, you can't issue this. You can't say that if someone is disruptive in your mental health resource, that the immediate response is to call the police and have them charged. Yes, that gets them out of your hair, but it puts them in a much more problematic situation where they're likely to end up in isolation. So I think we have to keep talking about it. I'm really glad you're doing, I want to see your film. I'm really glad you're doing documentary film work on this. I think, I don't know of any other way but to have people see it for themselves. And, you know, I started doing this work, but going into the prisons, not because I had any training. I wasn't a criminologist. I wasn't a sociologist. It's because I couldn't understand, like, how is it, you know, I went into prison and it's all poor people and racialized people and, you know, people with mental health issues. That's not what I was taught in law school. The law is supposed to apply equally to everybody. You know, how is this happening? So it was really trying to interrogate that for myself that led me down these paths. Maybe if I'd started with a more socially progressive position, I would be even further along than I am now. But it, you know, I've mostly learned by making mistakes, and I've made lots of them. But you know, one of them that I don't think is a mistake is to keep demanding to know if I don't get this, if I don't understand how this happened, how can anybody else get it? And so it's made me work through my own biases and when they come up, because bias, you know, we're all human, and when I make mistakes or when biases come up, I try to really investigate. Okay, where did that come from? How did I think that before about this issue, and how do I correct it? So, thank you for the work you're doing. Thank you all for the. You know, I'm fascinated to learn about what you're all doing.
All right, let's go for one last question.
Hi. So I'm a faculty over in the business school, and my research agenda focuses on the calls for justice. And so essentially my entire day really is about convincing people within the business world that this is a problem for them too. Looking at the fact that, you know, if 1 in 10 people have criminal records, that's an employment issue, right? There's a recidivism aspect of it. The fact that people who are entrepreneurs, that they don't get access to capital for be able to finance their business to get themselves, you know, better. So one of the things that I've really been struggling with is convincing other business faculty at conferences or whatever, is that my research is business and that it's relevant. So I'm just wondering if you have any advice on how I can start talking to extraction, for example, around missing murder Indigenous women, and how man camps have a significant, one of the biggest issues in regards to that space. And then yet they still don't think it's a business problem, right? So just wondering if you have any advice on how I can navigate that space, or if there's any reports that exist about navigating that.
So Justice for Girls is a group that I've worked with for a long time out of Vancouver, who are actually trying to counter, working with some of the Squamish matriarchs in Squamish, BC, to try and challenge the man camps. There's 2 LNG man camps that are going in there. And so I can put you in touch. I really want to follow what you're doing, though, too, because I think it's vitally important. I mean, that we tie these. And as you know, 2 of the missing, calls for justice involve guaranteed livable income in the MMIWG. So there's, we have to work on these issues. I mean, it's partly why I went on finance. It sounds silly, but I thought, where's the money come from? And when I realized how little of our how many of our tax dollars are like gone off somewhere else, I was horrified. I knew that we had a problem with money laundering. Canada's, that's because of some of the people I know who talk about it's way easier to move guns, traffic people, traffic drugs in this country than it is in many other parts of the world, because we have numbered companies and, all of that sort of thing. So I'd love to learn more from you about how we can work together. So I don't have a particular report on it, but I know some people who are doing some work, and I would love to learn more about it and figure out what I should be doing about it. So it gives me better questions to ask in committee.
All right. Well, please join me in thanking Senator Pate for coming out. Token of our appreciation. Thank you. A couple of other quick notes. Thank you to Jim Ocker, our tech guru of Saint of X. And as always, the brain behind all this is Dr. Anna Zhuschlag, who puts all this together. Thank you. So there's a few more events coming up. I know the DeVoe Center and Anthropology have an event coming up next week with the archaeology on the 21st. Is that right? I got the on down. Yes, and Elder Marshall will be here on the 30th. I think that one's at 7:30 as well in the barrack. Sorry. 7 o'clock. So keep those in mind as you're making your plans. We also have an ambassador coming on the 22nd. Dr. Lily Nichols will be coming. It's a joint event between the Mulroney Institute and Cody. And if anybody says they're bored, you're obviously not reading your emails that are coming up. So on that note, folks, have a lovely evening, safe travels home, and we'll see you at the next event.